Okay.
All right, well, let's get this show on the road. Good morning, everyone. Welcome to the third edition of this Spotlight webinar on mediation. I'm Aled Davis, co-founder of Mediate Academy, and Sabina, who will be introducing herself in a moment, will be setting some of the ground rules for the session. So if this is your first time on the Spotlight, we cover three key pieces of information. We have Spotlight on the Law, which is an insight into the legal and regulatory landscape, usually in Ireland, but sometimes we sneak in there some international focus. We have a Spotlight on Practice, where we try and share tools, tips, and insights, maybe a strategy to help you either if you're a solicitor going into mediation negotiation to be better at your job, or if you're a mediator, there will be some additional tools and tips for you as well. And then we wrap up with a Spotlight on an Expert, where we shine the light on one of our expert faculty who will be sharing a key insight from their practice as either a commercial mediator, and often our faculty are experienced practitioners, legal practitioners as well. All right, so I'm going to hand over the baton to my amazing co-founder and colleague, Sabina Walsh, who is going to be setting the ground rules for the session.
Thank you very much. I see a few wry grins in the background. I think you might have sort of somewhat overstated that, but anyway, not to worry. No giggling, Alfred, please. Good morning, everyone. Very nice to see you all. No ground rules as such, other than, as you'll notice, I've just muted everyone just so that there's no feedback, really, and because one of me is more than enough. And to drown out the barking dogs and things like that in the background. If you have questions, we would ask that you just put them in the chat, and there will be a Q&A session at the end, and we will go through the questions and answers then all in one go. Otherwise, we will overstay our welcome and keep you from your first or second cup of coffee of the day. So we are going to start today. I know we say focus on the law. This is, I suppose, an aspect of the law and practice, and an area of mediation that, as many others in this part of the world and many other parts of the world, are increasing. So we're going to have a quick look today at the insights we've gained from the publication of the annual report of the Workplace Relations Commission, which was published earlier this month. And before we dive into that, I just, for those of you who are not hailing from this nice damp country, the Workplace Relations Commission is the state body that deals with all matters employment, and particularly employment disputes in Ireland. An equivalent in the United Kingdom might be possibly ACAS, or the Employment Tribunal. Here, this institution, I suppose, has undergone quite a bit of development in recent years, and as we can see from today's report, is developing further.
Okay, so well, we've got a link to the report there for anyone looking for that link. But Sabina, so what are the key insights from this? I imagine it's a fairly lengthy report, and we've got a few minutes. So
it's meaty enough. So, but we want to focus, as always, of course, on the aspects of it that relate specifically to mediation. The WRC offers a number of different dispute resolution services and processes, but we want to focus on mediation. And I suppose the standout insight that we can get from it this year was the dramatic increase in the number of mediations taking place. which for once, unlike all other things in recent years, is not really to do with the pandemic. So there was a 31% increase in the number of mediations taking place under the auspices of the WRC in 2022.
So what is that? I mean, 31%, what are we talking in terms of numbers?
In terms of numbers, we are talking about 1,546 cases which were selected for mediation. And what that means is that the parties, when filing their dispute, selected the mediation option. It's important to just distinguish between the two mediation services the WRC offers. The first is pre-adjudication mediation, which is available for all rights-based complaints. So complaints under, equal status and equality, unfair dismissals, bullying, etc. They also have a workplace mediation service where they are available to go in and mediate what might be called the water cooler disputes that haven't escalated into a rights-based application, if you like, but they are the much smaller number. So these numbers we are talking about are about the number of people who said, I have a dispute here, I want to mediate.
Okay, so you said 1,500 mediations, is it?
Yep. That's correct. Of those, now those were people who selected mediation. Of those,
how many of those actually went to mediation, though?
658, because obviously both parties to the mediation, to the proposed mediation, have to agree to do it. Okay,
so 1,600, one of either of the parties propose it, but then the other side accept. So you're converting about 40% into a mediation.
Correct.
Okay. The big question on everyone's lips, what are the settlement rates of those?
Yes, so this is kind of interesting. This is one of the areas I'd love to study a little bit further. So if anyone out there is looking for a dissertation topic, here's a suggestion for you. So the WRC offers both face-to-face and somewhat bizarrely telephone mediation, which seems a little bit 1982, but is still one of the main forms of mediation that is offered.
Okay.
So out of this number, I'll break down the numbers for you.
Okay.
261 of the mediations took place by telephone.
All
of
right.
those, 53% settled.
Okay.
397 took place under the umbrella of face-to-face, of which 212 were virtual face-to-face, which we assume means online. Don't ask.
Okay.
Of those, 40% settled. And of the 185 that were in person, 49% settled. So some kind of differences in settlement rates there.
Okay, so I just want to summarize. So we've got 261 on the telephone.
Yep.
Of those 261, 138 settled.
Correct.
Okay. 185 actually turned up in a physical building.
Correct.
And 91 of those settled, so almost half. And then it's the virtual in-person, virtual face-to-face.
Yes.
212. Okay.
That's right.
That's interesting. And is that post-COVID?
I'm not aware of that. So the way they do their numbers is they only distinguish between the telephone service and the face-to-face service, but the face-to-face then seems to happen partially online and partially physically face-to-face. Okay. So not entirely clear. One final element on the numbers before we move over to the other insights from the report is that of all of those settlements, the vast majority, so 93%, involved a financial element to the settlement.
All right.
Which is interesting.
So 93% financial, the other 7% maybe a hug, maybe a bunch of flowers.
Who knows? A box of chocolates. Exactly.
Chocolates.
Exactly.
Don't knock it. The chocolate's always a favorite.
Exactly.
that's interesting. All right. So those interesting numbers. What were the other insights?
So the other insights to, I suppose, rather than insights to developments, and this is important for any of you who might be advising clients in relation to a workplace dispute or an employment dispute, and also maybe for anyone who's kind of looking for a bit of work, because there's been a lot of recruitment of mediators done by state bodies in Ireland recently. So two new things that happened in 2022 were a change to the unfair dismissals mediation process. Traditionally, unfair dismissals claims in the Workplace Relations Commission were all done on the telephone. But in an effort to increase the uptake, and we've seen an increased uptake, this has now defaulted to face-to-face. So the WRC now offers face-to-face mediation first for all unfair dismissals claims. So that's an interesting one to watch. That is as of June last year, I think. And the second thing that's interesting is what they've called a new late request mediation pilot. Again, in an effort, and I suppose the motivations to these changes are as interesting as the changes themselves, which is all to increase the use of the mediation service. So the new late request pilot means that if you go for the, I suppose, more common option, which is to look for an adjudication of your dispute, you can now do that, but still at any time before the hearing date, look for a mediation. So it means you can, I suppose, secure your adjudication date and work towards that, but even at the 11th hour, request a mediation, which the thinking behind, I think, is that parties might be put off from mediating because they don't want to delay getting an adjudication date. So that now has been changed. That pilot only came into being, as far as I'm aware, in November. So we'll have to see, obviously, in next year's annual report what the impact is. But in summary, the trend is very much both on the part of the Commission itself and, interestingly, on the part of people using its services to choose the mediation option, which for all of us, of course, is very encouraging.
That's quite interesting. So it's getting your date in court, which is your BATNA, I guess.
Exactly.
And using that a little bit of a carrot and a stick for the other side, I guess.
Precisely.
Interesting tactic. Okay.
Good.
Well, great slot. Thanks for that update, Sabina. Well, let's move on to the next section, which is the spotlight on practice. But before we get into that, let's run a little poll. So one of the tools we're going to be looking at in this next slot is how to use a decision tree to help analyze your BATNA, so you make an informed decision, or at least you assist the parties in the negotiation make informed decisions about what the best course of action to do is. But Sabina's just launched a poll, quick fire.
Yeah,
how often
don't think about it for too long.
Yeah, how often do you do a BATNA, WATNA analysis in negotiation or mediation? Most of the time, occasionally. What on earth is a BATNA?
Plenty of bats flying around here, but no BATNAs.
Okay, we've got almost.
I think almost everyone is there. Yeah.
Almost. Yeah, we've got two more responses. Or maybe that's us. I don't want to skew the results here.
Definitely
okay.
not. Okay, so there's our results. Ooh, interesting.
Yeah, most of the time, 63%, occasionally 25%, and what on earth's a BATNA? 13%.
Very good. Okay.
Brilliant. We're not seeing the results.
I'm sharing them now.
No.
Thank you, George. Thank you.
Good stuff.
All right. Have you shared them, Sabina?
I have.
Okay, excellent. Can I shut this down? Excellent. Okay. All right. So, you know, I certainly from my experience, most disputes have an emotional component, but I think you can guarantee that workplace disputes do involve quite a heavy emotional component. So as an advisor to a client in mediation, or if you're a mediator yourself, being able to assist your client or sister parties in making really informed decisions about what they want to do next in the mediation is really important. It's a key task that you have as a mediator, and it's an important duty that you have as a solicitor. And one of the tools to help you do this is a BATNA analysis. And knowing your BATNA can prevent you from falling into what's called the agreement trap, where the parties risk either agreeing to something that they might later regret, so agreeing to a deal that perhaps doesn't improve on their BATNA. And by the way, for those unsure what a BATNA is, the 13% in the poll, the BATNA is your best alternative to a negotiated agreement. So what are your options if you choose to withdraw from a negotiation? What are your alternatives? Or if you are deciding on whether to negotiate or mediate, what are your alternatives? Knowing what your walkaway position is really key. I'm going to help you with a tool called a decision tree now. And to do that, we have a case. What's the scenario, Sabina?
I should probably unmute myself, whatever about anyone else. We have our friend Walter here, who, as you can see, is clearly distressed by his situation. He is suing his former employer for unfair dismissal. He's claiming 46,000 in unpaid wages and compensation. His lawyer has advised him that he has a 50-50 chance of winning either in court or at adjudication. And the lawyer has said, somewhat conservatively, some might say, that it'll cost him another, whatever he's paid already, 4,000 euros at least to get to the other side of the adjudication or the court. Okay. In mediation, right, go ahead. Yeah.
Well, I was just going to say, Walter is the chemistry teacher that we all know and love.
Yes, indeed.
Yeah, okay. So where are we at then, Sabina?
So we are in mediation.
All right, okay.
And in mediation, the employer, the school, has offered Walter 20,000 euros in full and final settlement of his claim. And his dilemma is now whether to accept the 20,000 or whether to take his chances in court.
Okie doke. All right. So let's look at a decision tree then. So decision tree really is a tool that you can use to make an objective decision. Now we're just going to focus on the financial aspects of the dispute here, of your BATNA. And it is the first stage in the decision tree. So 3 stages of the decision tree. The first stage is you kind of map the decision tree. All right. So you start off, you've got the decision diamond. Okay. So we're in the mediation. There's been an offer on the table of 20,000. So you can accept that offer, or you can decide to withdraw and try your chances in court. Okay. But there's a chance if you go to court or adjudication in this instance, you can win or lose. And your lawyers advise you that you have a 50-50 chance. So settlement offer 20,000 and a 50-50 chance of winning if you go to court. If you win 42,000. 46,000 is your claim, but you'll have to carry your expenses of 4,000 to trial. And if you lose, you are down 4,000. So there you have it. Those are all of your key bits of data. The next stage then is to do a weighted average of the upper part of the upper branch of the tree, which is going to court, and what that looks like. So if you win, you've got a 50% chance of winning. 50% of 42 is 21. And if you lose, you lose 4,000. 50% as minus 2,000. So your weighted average is 19,000 euro. And this is the expected value of going to court. Okay. So you've got 20,000 on the table, but the emotions are ripping in the mediation. Okay. So this is why a tool like this can help you just figure out, okay, how do we make an objective decision here, so that if there is a deal on the table, that you can either decide to accept it or choose your alternative, which is your BATNA, in which case the moment your BATNA is 19,000, and you've got 20,000 on the table. So that's the decision tree, and it's a very simple decision tree, and it only applies to the financial elements of it. But there are other things that make that up.
Yeah, so I was gonna ask, because this is obviously a very rational exercise for someone who like Walter there is clearly very perturbed by his situation. So what about all the other aspects that go into evaluating that BATNA? What are those?
Well, I hear from solicitors all the time how, and actually company owners that have gone into litigation or mediation, how stressful the whole process is. And for workplace mediation, having done a number of employment and workplace mediations, I've got sort of secondhand experience of, how troubling and stressful and how consuming these processes are for people. So, there's a key element of the stress, the time that sucks up, and the opportunity cost of also just going down that top route is massive. And I guess in a workplace or employment scenario, then you've got publicity. If you go to court, then cat is out of the bag, whereas you keep it in mediation, mum's the word. So those are other elements of your decision process that are important to consider, I say.
Super. So, it strikes me that then whatever about the client, I mean, you'd like the client to obviously have the capacity to evaluate this, but certainly their advisor or their supporter would need to be skilled enough to be able to work through tools like BATNAs and WATNAs in order to reach a decision. And I think, Aled, I'll let you get our colleague Jane teed up, who is going to talk a little bit about, unfortunately, what can happen when the advisors do not have that skills and that knowledge.
Super. Jane Player is one of the UK's top flight commercial mediators, really accomplished dispute resolution lawyer, and is one of the 11 top mediators, independent mediators. And this is Jane being interviewed by Sabina.
What are the most difficult tactics to work with or respond to? Belligerence. In fact, I would say belligerence by lawyers who think it's good lawyering to simply say the same thing again and again and again and not to listen. Now, whether that's showing off or whether that's an inadequacy of their technique, I don't know. The worst combination is that combined with a weak client who, because of the poor lawyering, has never had an element of guidance around risk analysis. So if they truly believe they have a fabulous case because they're not lawyers, and you've got a belligerent lawyer who just is there for the fun of being able to shout about their case, it's really difficult to work with someone like that. And you get to the point as a neutral in really testing them as to is that really the right way to advise a client. So that's the most difficult trait that I've come across. It rarely shows itself. That double combination is rare, but it happens.
So I don't know if any of you have ever met that double trait. We might have to do another poll. But it just shows the importance of those essential skills and the ability to undertake a rational analysis, particularly if your client is being hijacked by their emotions.
Super.
So,
well, we have one question in the chat, and it's a question: do people often ask to negotiate a reference in workplace employment mediations?
I know you're smiling because we were only talking about this yesterday. Go ahead.
Yeah, very interesting. I was these are some years ago now, and it was a really complex employment dispute. And the whole one of the elements of the agreement was a reference. And one side felt that if they were giving a glowing reference, that it would raise a red flag for any future employers. And actually just having a bland, vanilla, standard reference was the best course of action. But then sometimes if people give a bland, vanilla reference, then that could also raise red flags. So I guess, as mediators often say, it depends, but I don't know categorically. But when that comes up, it's certainly a discussion point that people have to weigh up experiences on each side. Sabine, do you have any thoughts on that?
Yeah, no, I mean, it's a really interesting one. I've encountered it as well, because I mean, I've encountered it quite frequently as something people would ask, but that can be difficult to get, if you like, if you're the person asking, because unless there's been a lot of repair of the relationship done in the mediation, an employer might say, look, you're asking me to lie effectively if I'm going to write a good reference for this person who, rightly or wrongly, I felt the need to sack, say, if it was an unfair dismissals. So it's quite a tricky one, but I have also been in mediations where I suppose a reference was crafted, and very much I use that term, crafted jointly by the parties, that both parties were then happy with and could stand over. So it's a very relevant question, and one that, as so many things in mediation, doesn't have an easy answer.
Brilliant, super. Okay, folks, it's 8:30. Time to start your day. I hope you found this session useful. If you did, you might consider signing up to our newsletter, which is a monthly newsletter. It comes out on a Saturday morning, the last Saturday of the month. And it takes about 8 minutes to read, so you can have a cup of coffee and just
dive in before you read the Irish Times.
expand your brain. Second, we'd ask, we're a new up and coming small business, and we rely on goodwill and recommendations. So if you found this useful, please do spread the love. Encourage other people to join the spotlight or sign up for our newsletter. That would be super. Sabina is going to send out shortly a registration link for the next spotlight, which is going to be on June the 20th at a nice and early 8 a.m. So hopefully we'll see you all on that session. Have an awesome day.
Thanks, everybody.